we're going to take up chapters 10 and 11 of the report on Health and Human Services. Those chapters specifically relate to the Office of Inspector General. And I would call back up, well, I would call Ken Levine, Joe Walraven, Sarah Kerschel, and Danielle Nasser? Nasser. Okay. Let's see. Do I have out of a page 8? There it is. Okay.
Could I ask a point of clarification, Madam Chairman?
Maybe, maybe not. Go ahead. Was it about this? Was it about your acceptance to be on the work group?
No, ma'am.
Okay, then I'll recognize you, yes.
As I understand it, that committee is to consider the 3 questions that you posed.
Well, or any others related
Correct, but I mean
to.
that there was not 3 committees to consider those 3 questions.
There
was one.
Consider,
okay.
Right.
That's
Under
all.
the leadership of the vice chair, he'll make sure you address all those. Thank you. Those seem to be the big overriding issues. Okay, Ms. Levine.
Well, thank you. Sarah Kirkle's going to lead off the discussion on the Office of Inspector General.
Good afternoon, Madam Chairman and members. My name is Sarah Kirkle, and I manage the Sunset Review of the Health and Human Service Commission, including the Office of Inspector General, or OIG, which are issues 10 and 11 of the HHSC report. I'm going to highlight issue 10, and then Joe Walraven's going to highlight issue 11. First off, OIG is charged with preventing, detecting, and investigating fraud, waste, and abuse in the Health and Human Services system. OIG employs 774 staff and operates on an annual budget of approximately $48.9 million, growing more than 30% since 2011, and raising expectations for increased efforts to combat fraud, waste, and abuse. This Sunset Review marks the first comprehensive evaluation of OIG since its creation in 2003. While OIG has a valuable role to play for maintaining the integrity of high-dollar public assistance programs, staff found that OIG is in need of fair, defensible processes and results to back up its bold assertions and tough approach. While many of staff's recommendations in issue 10 are for tools that can be described as bureaucratic in nature, they are sorely needed to restore trust in OIG. Historically, OIG's enforcement division has been fairly inactive. OIG's recent efforts to take a more active role in pursuing fraud, waste, and abuse have garnered much attention and scrutiny and raised significant questions about its processes and results, or lack thereof. Staff found that OIG's highest profile responsibilities, its investigative processes, lack structure, guidelines, and measurement of data needed to analyze and improve its processes and outcomes. Absence of basic tools, such as decision-making criteria to guide its investigative work, potentially result in inconsistent results and unfair investigative processes. Inefficient and ineffective processes lead to limited outcomes and a modest return on investment for the state. These concerns, taken in sum with other issues, such as poor communication and transparency, limited staff training, and a lack of performance data from a case management system, point to limited oversight and the need for further review. Staff recommend a series of actions to strengthen OIG's processes, as well as a special sunset review in 6 years. OIG also performs many functions that don't align with its fraud, waste, and abuse mission and would benefit from an increased focus on its most critical functions. Additionally, the Inspector General's gubernatorial appointment and OIG's creation as a division of HHSC raise questions about the Inspector General's accountability to the Governor versus the Executive Commissioner. Staff recommend removing the gubernatorial appointment and requiring the Executive Commissioner to appoint and supervise the Inspector General. And now I'll turn it over to Joe.
Madam Chair, members, I'm Joe Walraven again with Sunset staff, and I'm going to quickly take you through issue 11 in the report, and that's the issue dealing with the credible allegation of fraud payment holds, or known as CAF holds, which you'll be hearing a lot about. OIG has long had the authority to place payment holds to stop the flow of Medicaid payments from the state to providers. However, it's the Affordable Care Act that now requires states to suspend Medicaid payments to a provider who's under investigation for that credible allegation of fraud. This CAF hold can continue as long as OIG is investigating the alleged fraudulent payments, but providers do have the opportunity currently to appeal to the State Office of Administrative Hearings. Appealing a CAF hold is only the first part of a separate process for determining the amount of the overpayment that the provider actually owes to the state. So in this issue, staff found the staff focused on the CAF process, finding that it goes beyond its intent as an expedited matter designed to mitigate the state's financial risk in its Medicaid payments. Instead, the CAF process ends up largely duplicating that separate, more involved overpayment hearing. In short, the CAF hold hearings have gotten blown out of proportion, especially when you compare them to other expedited hearings that licensing agencies hold right now with doctors and nurses. The staff recommends streamlining this process by providing for a truly expedited hearing at SOA and clarifying the standard of proof that the OIG must show. In this way, the state can deal with these CAF holds more quickly and get about resolving the actual overpayment more expeditiously. Staff also recommends clarifying OIG's authority to place payment holds only in serious circumstances, which would have the effect of restricting OIG's ability to use payment holds in standard overpayment cases or for non-fraudulent errors. This would not, however, affect OIG's existing authority to pursue these matters through the overpayment process. And that's our quick testimony, and we're available for questions on either of these issues.
Questions, members? Senator Hinojosa.
Madam Chair, I read the report, and it just confirms many of the complaints and concerns we've had here in the members of the legislature and some of the healthcare providers. I thought the Sunset Step did a very thorough job. The Office of Inspector General is a very important office for a state, for them to look out for fraud and end up, quite frankly, prosecuting those who commit fraud. One of the complaints has always been that they have a very white net and bring in a lot of people who are healthcare providers who are making clerical mistakes, and they're not involved in fraud. And many times some of the methods are used in terms of providing due process, in terms of using terminology that it becomes just boilerplate terminology or credible evidence, and the addition of liability without any explanation. This really confirms some of the changes that we need to make sure that the Office of the Inspector General does go after those who try to cheat the state and commit fraud. And we don't end up bringing in a lot of innocent healthcare providers who maybe made a clerical error. And some of the recommendations, Madam Chair, also struck me as many times using the extrapolating techniques. The Office of the Inspector General exaggerates the amount of money they would collect. In turn, they would cause problems for us at the state because the federal government, CMS, will hold us accountable that we actually collect that type of money when it's not actually there in terms of collection. And I could go on and on, but I'm just looking forward to making some changes, and I saw where the Office of the Inspector General agreed to many of the recommendations being made by the Senate Commission.
Thank you. Representative Dutton.
Thank you, Madam Chair. I too have read this report on the OIG, and I was somewhat concerned because OIG is so important to the whole operation of this agency and certainly the people who receive the services from this agency. But it seemed to me that somebody needed to be watching OIG almost. For example, as I understand it, when OIG investigates for fraud, for example, that the way their procedures work is that you're entitled to certain due process rights under an investigation for fraud. Is that correct?
Yes.
But if a fraud is not alleged, you're not entitled to those same due process rights.
I think you're speaking of Senate Bill 1803 last session.
Correct.
Put into, it codified a lot of OIG's processes into law, and so there is much more process on the CAF process than there is just generally for the overpayment. And our recommendations would actually streamline that. We feel like while it can be viewed as due process, we feel like the point of that appeal is very much to be expedited, and so we're trying to rein that into what we feel is appropriate.
And so your recommendation essentially would do away with whatever procedure they have in place now.
That's correct.
Also, so I understand that the governor actually makes the appointment of the OIG and does that for 1 year.
Yes.
Wait, do you know why we did that?
Do not know why that is in place. However, just in our research, our HHSC-OIG is the only OIG in the state that is appointed by the governor.
Well, that's what I wondered. Yeah, that's what I wondered.
The rest all report either to an agency head or a board.
Or board, or somebody appointed by the commissioner.
Right.
And I believe one of your recommendations was to change that so that now the commissioner would actually appoint the OIG person.
That's correct.
Okay. Are there other... Well, I guess I'll talk to the agency when they come up, but I just wondered about some of the other things that have come to my attention based on the practices or policies of this agency. And so I'll reserve there, Madam Chair. Thank you.
And I might be able to help clarify a little bit. When we created the Office of the Inspector General in 2003, we specifically, I mean, it was our intent to not have that person report to the commissioner. And you know, I'd love some assurance that we could retain independence of this office under this proposed structure.
A few considerations related to the independence issue. Right now, the federal law requires that if the program integrity functions for Medicaid and some of the other public assistance programs, but especially for Medicaid, it has to be within the single state agency, and that's why it is established as a division within HHSC, but appointed by the governor, I think, for that independence. Certainly, that is an element that you'd have to consider in making this making your decision about this recommendation. We feel confident that if there were any issues where the OIG felt like they weren't able to exercise the independence that they need, that there would be an avenue to bring in someone like the Texas Rangers. Right now, the Rangers are currently investigating an employee of OIG, so this is not in a common practice, and it occurs in other agencies.
Madam Chair, I was just going to respond a little bit. The problem I had is that, and I realized, and I remember when we did that, we wanted to make it basically independent of the commissioner. But then when I looked and I saw that all of the other OIGs, all throughout the whole system, none of them really appointed by the governor. I thought, well, why did we pick this agency? I couldn't remember why we ever did that, and we only allowed the governor appointed for 1 year terms, which also didn't seem a little strange to me. So the person taking the job actually goes in and by the time, I guess, they find their way around a little bit, it's time to try to seek a new appointment, maybe. But I think this organization, the OIG, is so important, and I do respect the right that the legislature imposed in terms of being independent. And I'm not sure whether we have that now or to what extent the changes recommended by the Sunset staff may impugn that at least appearance of independence.
That's why we're here.
Yeah. So anyway, that's why they pay us the big bucks, I guess.
Representative Raymond?
First of all, this is another example where you all have done, in my view, an excellent job. We've been dealing with this, some of us, for some time now with the Office of Inspector General and the work they're supposed to do. And it's to me, a very, very important function that we have. I mean, you know, I grew up in Duval County, a little county in South Texas, and I got involved in politics because I saw a lot of corruption, and I wanted to stop it. So when you have an office like this, I am absolutely for what their mission is. All right? None of us here, I don't think any of us here, want any agency, and certainly not the Medicaid program, to be one where people can go in and steal. We don't want that to happen. And so we set up the OIG's office. Now, what we have seen, however, in recent years, I guess, is it's just questionable whether or not they're doing the job they're supposed to do. I want them to find anybody who has stolen, because that's what it is, stolen, and I'd like for those people to get prosecuted and go to jail, because that's, in my view, that's how you stop people from wanting to continue doing that, or from preventing others from doing the same thing. That's the way you do it. But by the same token, you know, I don't want the IRS or OIG, and I say IRS because many years ago when I worked for then Senator Lloyd Bentsen, I worked on a lot of IRS cases, and I saw the IRS abuse their position many, many times and hurt people many, many times unjustly. And I don't want any state agency to do that either. And I think you all have done a very, very good job of going in, peeling back the layers of the onion, and looking at what their job is supposed to be and how they're supposed to be doing it and where they have fallen short. And so I think you've come up with some really, really good recommendations. Let me ask you, I do want to ask, you know, I personally don't have any problem with the governor making the appointment. I really don't. Governor appoints a lot of people that do a lot of good jobs around the state of Texas. And I'm sure this new governor will appoint even better people, by the way, to do a great job. But let me ask this. I suppose that part of why we would want the, quote, independence, and this is where I want y'all to comment on, is that when they're investigating cases, right, presumably you want the independence because somebody within the state agency that they're investigating may be in collusion or working with someone who is doing wrong. Is that right? Is that the case?
There's that potential.
That potential. So having looked at the work that they have done, have you found that in fact there were many instances where when they were looking at wrongdoing, there were in fact people, I guess we have a recent example of someone who was either incompetent or was actually working to hurt the private sector, presumably, as opposed to, you know, trying to benefit himself, right? But did you find examples of where they found someone they were investigating that was in the agency and doing wrong inside the agency?
I don't know that we got that specific, but they do on a regular basis investigate employees within the HHS system.
And so then if you found that, did you find that many of those employees in fact were fired, sent to jail, whatever?
I don't know that we have that data. A lot of the employees too are employees within the state supported living centers and state hospitals, and so there could be any number of actions that result from those cases.
And so the thought being that in fact the commissioner, the executive commissioner hired the head of OIG or the inspector general, the thought being that the commissioner could unduly influence him not to do something or to do something. Is that the thought?
That's the thought.
Okay. And now you've laid out, so in any event, I understand the reason for, quote, independence. I don't have strong feelings about, you know, the governor appointing or the executive commissioner for that matter. But as you look through this, I mean, I read it and I look at it as an agency that's just broken. And I don't know if you all, it seems to me by your observations and your recommendations that you agree with that, but, you know, do you think they're doing a good job in any way?
I would say it's difficult to tell. And the reasons why it's difficult for us to tell is because they don't have a lot of data to show their outcomes and show what is resulting from their process. We know we've got a lot of, just let's take investigations for example. We've got a lot of cases coming in the door. We've got a huge backlog of cases and we aren't really having a whole lot come out on the other side, and we can't figure out why that is. So I guess in the way that we work is in order to determine whether or not they are able to demonstrate their outcomes. In the absence of data, you would look for policies and procedures to make sure that you have a structured process in place to get to your end goal. And the types of policy, they have policies and procedures, they have a lot of them, they send them all to us. What is lacking is the pieces that we find most critical, which are guidance to the employees on how to make their decisions so that the way that they approach their work is consistent and people are treated fairly. So regardless, we certainly didn't get to the level of detail on being able to prove whether people are treated unfairly, but we do know that the policies that are in place to prevent that from happening, they are not in place, and that's one of our recommendations. And so we're looking at the top of the organization. You know, we've got, we heard some comments about, well, guidelines could sort of hem us in create a situation where we don't have the flexibility to do things on gut feelings, for example. We think it's very important to have a much more defined and structured process, and it sounds very bureaucratic, but it's key, especially in the absence of data, to know that you're
Well, but you
moving towards
pointed
the right
out
thing.
specifically, for example, that if someone requests a SOA hearing, that they have to put up a deposit, whereas in other cases, they don't have to put anywhere nearly as much as what they're demanding of those cases. You pointed that out. Certainly, it read to me as something that was in fact unfair, right?
And that was a decision of the legislature. That wasn't OIG on its own in that specific case.
Right. All right. So
Fair.
then it's something that and when did that?
But it is unfair to providers.
And when did that
compared.
get instituted? Just last session,
Last
1803,
session. Yes, last session.
And, all right, and so was that something, as you looked into it, was that something that OIG had recommended, or was it one of them? I know it wasn't me.
Yeah, my understanding is that was a negotiation between OIG and some providers during session in the process of moving the bill through. I don't know whose idea it was initially, but at the end of the day, it is unusual for state government to have providers have to put up a share of the money. So we did recommend that OIG absorb the cost of those.
You addressed a little bit the ACS Xerox issue, right? Not a lot, but some. I think you all touched on it, didn't you? You said that, for example, that we now have a lawsuit. And by the way, let me just go on the record saying that I thought it was responsible and gutsy for then Attorney General Abbott. Well, he's currently the Attorney General, but for General Abbott to move forward on that lawsuit relatively close to an election, right? Because I think it's a lawsuit that says, we're suing you because you guys have cheated us out of a bunch of money, taxpayers out of a bunch of money. But by the same token, it brings the response, as you all noted in your report, from the federal HHSC saying, you know what, we don't care, it's your fault, because that was your contract, you were supposed to make sure that they were doing the work they're supposed to do, you didn't do it, it's on you, Texas, you're going to have to pay something here. So I thought it was very gutsy for the general to move forward on that, but I think he did because it was egregious. I mean, what the contract that the state had with Xerox at this point, you all touched on it. Were you able to, do you have an opinion on whether or not the AG's got a good lawsuit that they filed on behalf of the state?
We didn't take a position on that. It was actually, I think, issue 2,
Yes.
Carl's Administrative Support Services issue, and as an example of the need for strengthened contract oversight at HHSC.
Mr. Raymond, we steered clear of the prior authorization issue in our discussion and our development of the CAF hold issue. We did not get into that.
Well, but the issue of the agency having a terrible, process for prior authorization, that contract. Again, when you enter into a contract, and Commissioner Janik referenced this, and so did Mr. Lusso here, we spent a lot of money on contracts, right? Basically, now the state does and this agency does. But when you enter into a contract, especially when it's hundreds of millions of dollars, you would think that we'd take a little harder look at making sure that the people that are supposed to be doing the job they've agreed to do are doing it. And if they're not doing it, you don't re-up the contract. But that's what happened here more than once, correct?
We try not to comment because of the pending litigation.
Which makes sense.
Let me tell you something, on the pending litigation, you're on our side. Okay, it's okay. You're on our side, not theirs.
I can answer some of that, but not, I agree totally with Sarah on the last point, but I think Dr. Janik alluded to it also in his comments that they recognize that, well, there's fault all around the place, but anytime you have a failed contract where something isn't being done, part of the responsibility does fall on the contract managers to properly manage that contract. You have to ask the question anyway, is, how well they were managing the contract. Dr. Janik alluded to elevating the position and role of contract oversight in the organization at HHSC. In part, I'm sure, because of that purpose and because of them becoming such a contract management organization, as Mr. Luce talked to before, about that being such a huge role. So that's, we just want to make sure that everything's in place, and we have an issue where we talk about contract management, so that too.
Let me ask you, does it make some sense, since the Attorney General has the Medicaid Fraud Division, does it make some sense to move this office over there under the Attorney General? Again, you've got independence from the agency over here, right?
We did look at their relationship, and their relationship seems to be working fine. We didn't come across any major problems. But there is still a requirement in federal law that the program integrity functions for Medicaid be within HHSC as the single state agency. And so moving that function away, the federal law is very specific that the criminal portion, Medicaid Fraud Control Unit, did I say those right order? Okay, is specifically required to be outside of the single state agency for that independence. The program integrity function is required to be within the single state agency.
Okay, we're going to have Mr. Wilson up here, Madam Chair, in a little
Yes,
while.
sir, but we got some other questions first. Sunset. Senator Hinojosa.
Yeah, just a couple of follow-up questions. I read in the report that it takes on the average 3 years for them to finish the investigation.
That's correct. Or that's the length of their investigation?
Just the length of the full-scale investigation itself, not from beginning to end.
3 years? And are there some cases that are still open as long as 10 years later?
The backlog, I think, dates back to 2001.
And many times, many of those healthcare providers go bankrupt and put out of business. Is that correct?
Yes.
Okay, well, I'm asking the question from your report. So I guess one of the things that I noticed in the report also, I know that many times we asked the OIG about how they identify fraud cases, and they don't seem to distinguish between actual fraud or clerical errors made by staff.
Yes, and what we tried to do is address, looked at that specifically in relation to the extrapolation and what we find to be very large overpayments, and not really taking a position on extrapolation itself, but if you're going to use extrapolation to make sure that there is in our opinion, a fair and consistent policy for how that is applied. Right now, the way the process works is that an investigator within OIG would take a sample of records. They would look at the records, and if they found things to not be up to par, then they would decide whether or not they would recoup the full payment for that claim, or whether they would just be partial. We think according to our read of the federal law, they have the ability to not recoup the full amount. We recommend that they have a matrix that lays out, based on the nature of the violation, that you would scale the amount that you would recoup. So for example, if a provider had no documentation that a service was even provided, then you couldn't prove, and there's no reimbursable level of service there. So that might have a full recoupment of the state funds. If it's just a minor clerical error, that you would be able to scale that, and maybe there might be a penalty, or you might recoup a portion of that, but you wouldn't, in all the cases, recoup the full amount. And by doing that across the board, you end up with very large overpayments.
Also, anytime I would ask for information from them, they would always come up with this, seem to be hiding behind federal statute and federal regulations by saying that we're required under the federal law and rules, there's a credible allegation of fraud, and there's an addition of evidence. And the reality is that that's not necessarily truly 100% correct. States do have a certain discretion with the parameters of the rules and federal law, because other states have better defined credible allegations of fraud than we have here in Texas, the OIG has.
I would agree with that. The states do have some discretion on how they apply that. One of the limiting factors for OIG, however, is the definition of fraud in statute. It is very, very broad. And so in that respect, the agency does feel obligations, whereas maybe a normal person may see fraud as something that's much more intentional. In the case, the state statute, when it defines fraud, it's very broad, and so a lot of maybe unintentional acts would fall under the definition of fraud, and by that, the agency would then feel obligated to place that hold.
So there doesn't seem to be objective criteria or guidelines to make and guide their decision-making process.
On their decision-making process, certainly we have recommendations to improve how they make those decisions, to make sure that they apply their decisions fairly and consistently.
You know, many of us have been dealing with this issue in the OIG and now for years, and sometimes we get the impression up here they make up the rules as they go along.
And certainly that is the result of the lack of very clearly defined guidelines and criteria. When you have those, it really helps an agency's ability to defend their decisions, because it doesn't give the appearance that a decision was made in this case and this case, which may be comparable cases, and you don't have any sort of guidelines, you don't have any sort of defense on why you made a decision here and not here. And so our recommendation is really to help the OIG, by putting those in place, be a stronger and more credible OIG in their decisions.
And I would assume that if we made some of the recommendations, or at least accepted some of the recommendations, we could really target those health providers who are committing fraud, because we know what's happening, to better use our resources to get back some of the money that's being stolen, basically, from taxpayers.
And while they have started to prioritize what they seem as more high-risk providers, and they have these initiatives where they do those priorities, we're really trying to gear in when they decide to open a case at all, and whether they decide to pursue a case for a full-scale investigation, that you would prioritize those that are probably the highest risk and would return the most amount of money to the state.
And one of the things that I notice, and I always have issues with this, because the extrapolation theory. I know that they had an issue with one of the, investigators or agents or employees that they use. They was accused of committing fraud and, quite frankly, misrepresenting and lying about some of those extrapolation reports. Now, part of the problem that I see is that there seems to be a lack of management oversight to make sure that there is quality assurances in terms of the work that's being done by many of the employees, not only the extrapolation experts, which I've seen many times get completely neutralized in court, but also the investigators they have. I always said there was a lack of training in terms of the investigation techniques they use. Did you find any issues there?
So certainly there is an issue right now with an employee of OIG where the statistical validity of some of the samples was called into question, and the agency is taking actions to re-pull samples on those cases to make sure that those proceed properly. I guess our recommendation is to ensure that you have staff to oversee that quality assurance process, to make sure that they're pulled appropriately, more as a way to keep us from having to resolve these in court, for example, because that would increase the legal costs on the part of the state. So having that ongoing quality effort would help us ensure that what we're doing and when we pull those statistical samples and how we extrapolate them is in accordance with policies.
Do you know if any of those cases where the expert or that person was involved, that employee was involved, was that any of the money returned to the healthcare providers?
I think that this issue, and Doug can provide more details on this, but I believe that the issue was caught before any of them went to any full hearing, but he could provide more detail, and I don't know all of what is public and not public on that.
And I guess now the issue is, and we've asked for backup before when the OIG says that there's $1 billion worth of Medicaid fraud out there. And then they don't collect but maybe, I don't know, 5%, 10%, or very little money of that, or $1 million. Does that commit the state of Texas in terms of what CMS or the federal government expect us to refund once we make those type of,
Claims.
I guess, comments.
It does not. The way that that specific figure was identified was overpayments identified. I think the agency is reconsidering whether that's something that they want to continue, but we are not committed to having to return any money to the federal government until the OIG issues a final notice of overpayment. That is one of the last steps. So we have a series of processes to make sure that once we issue that final notice, because when we do that, that means that we're on the hooks for providing the federal government their share of the returned money. We wait until that's one of the final steps in order to minimize any.
Yeah, one of the things I noticed, and maybe I ought to ask the OIG when they come and testify, in the response, they also had concerns about SOA being the final decision maker in terms of cases that they had to hear. They made it seem like it was only the OIG who really understood Medicaid and fraud. And I know for a case that there are many judges that try medical malpractice cases or any type of case and are able to make decisions based on the evidence before them. But one of the issues that's come up is I noticed also that many times you have a SOA hearing where you may have 2 or 3 months worth of testimony. And then that case is kicked back to, or referred back to the Health Service Commission, and they just within 2 or 3 days reverse the SOA judge. That's what the statute says, or that's how the structure's set up right now, correct?
That's correct.
Okay. To me, that certainly gives the impression and perception of bias, not being objective. You're a administrative judge working for the commission itself, and not being independent in terms of outside pressure, if you will, making those type of decisions and trying to reverse a SOA judge has been involved, and that's another issue we have to deal with, but I think at the proper time we'll look at it. Thank you, Madam Chair.
Representative Dutton?
Thank you, Madam Chair. One of the issues that I sort of perused in your report had to do with OIG pursuing violations that occurred even despite a licensing agency, for example, the dental folks not having a complaint with a particular dentist, for example. Did you all get very deeply into that?
No, as we did see some responses from stakeholders who suggested that maybe clarifying that certainly a standard of care issue should more appropriately be dealt with at the licensing agency. However, I would caution that there is a very fine line there, because when a provider provides services, determining medical necessity, for example, is something within the realm of the Medicaid program, and so it would fall within OIG's jurisdiction to make a call on that. But so there is a very fine line there.
Well, yeah, and I guess OIG sort of, decides at this point where that line is, or is that defined by federal law or something?
It would be an interpretation of federal law and the state Medicaid policy.
And where the licensing agency and OIG differed about that, who wins?
I don't know that I don't know that there's a winner. If something is clearly in the realm of the licensing agency, OIG should be referring that to the licensing board. But I'm not aware of intersections of those cases.
That's happened.
Right.
The other thing I had a question about, and this bothered me to a great extent, the agency that we've empowered to ferret out fraud has been accused of fraud. And I think this question of independence has somehow or another been dragged about to the point where we may have created some other problems. What's the qualifications to be the OIG, do you know?
To be the Inspector General?
Yes.
I need to get back to you. I don't know that I have that in my notes right now.
And do you have to be a lawyer or
You do
anything,
not. There are no experience requirements. Certainly, you don't.
So
need
you
to be
don't
a
have
lawyer.
to.
Mm-mm.
You just have to be appointed by the governor. And you don't have to have any prior experience in investigative functions or anything like that?
Not aware, but I will let you know if there are any experience or other requirements that we aren't aware of.
All right. And finally, I'll save it for the agency, though. Thank you, Madam Chair. Yeah.
Thank you. Any other questions of Sunset staff? Thank you. Oh, I'm sorry.
May I just add one thing to Mr. Dutton's, because he started asking the independence question, didn't finish. I'll be really short. And both Mr. Raymond and Mr. Dutton mentioned it. All the questions that have come up lately, since then, have been about the management of the office and of the agency. And the idea behind the commissioner making the appointment is that the commissioner then has responsibility to ensure that that office is operated properly, that the commissioner is the boss of the inspector general. Now, and right now, Commissioner Janik doesn't feel like he can go in when he knows there's management problems at that agency, at that department of his technically. He doesn't feel empowered to be able to go in there and fix those because Mr. Wilson is an appointee of the governor and a separate entity. So he does not do that now. There is a trade-off, though. If you want the commissioner to be able to oversee and ensure the operation and be accountable for the operation of that office, there's the trade-off for the appearance of independence.
Madam Chair, could I?
Yes, Representative.
Could you have sort of a hybrid system where maybe Janik selects them, but the people that Janik reports to actually determines whether they get terminated or something? I mean, because that's the independence that I think you're looking for.
I think in that situation, you may have a situation where there's blurred accountability. One other comment on the reason behind the recommendation. We were in talking with a lot of the stakeholders and with the agency and our own observations. OIG is not as familiar as maybe they should be with a lot of the HHS programs, so they're enforcing the requirements of these programs, and so it's a careful balance between making sure that they're far enough away to have that independence. They still need to be close enough to have a better understanding of those programs, and we thought that moving them under the more direct supervision of the executive commissioner could aid in that relationship. Right now, that relationship is strained.
Yeah, that makes it, bothers me even more. If they're that far away removed from the operation of the agency, it's difficult to see how they could ever be a functioning organization to ferret out fraud. I mean, if that's what the whole intent is, because how would you know it's fraud?
With proper training and how those programs work, then I feel confident that they could, and they have been making a lot of efforts to gain more expertise. For example, with recent changes into managed care, they've been making a large effort to have a better understanding of how that works.
Who's responsible for training the OIG? The Inspector General?
The Inspector General's office is on their own.
Responsible on their own, yeah.
Resources are around the system.
Okay, all right, thank you.
Mr. Lewis, did you have a question? Okay. Any other?
I would point out that there's always that balance, and at the federal level, the Inspector Generals report, they are Senate conferees who do not report to the head of the agencies. And there's trade-offs of both ways, as he pointed out. Then you have somebody who may be completely autonomous with no knowledge of the programs.
Yeah.
There's just a balance, there's a competing interest there.
What do most other states do? Did you look at that?
Well, the program integrity functions, again, are required to be within the single state Medicaid agency, and there are any number of different structures in other states.
But who appoints them?
For the most part, I do not believe that they are necessarily even appointed. It could be a range of either appointment or just hiring someone to fill that position within whatever HHS structure you have.
Okay. Other questions, members? Well, thank you, Sunset. Good job. And now the